from the board just to let you know we do have a fabulous spring trip, which you may have seen in a bulletin or on a TV screen, to Fredericksburg, April 30th to May 2nd. It's 3 days, 2 nights. We're going to do some really fun stuff. We have information on that if you'd like to go. But you might look into that. We're going to have a great time. Andy Robb, where's Andy? Are you here? Raise your hand. Andy's going to be our speaker. And so we're going to have a wonderful time. But please consider coming and going with us. Also, we're just going to have a fun luncheon, spring luncheon, just have lunch on, put the date up here, May 9 at the Park City Club. You shortly will be able to sign up for that. If you'd just like to come have lunch that day, there's no occasion. It is simply enjoy spring, come have lunch with friends, and share the moment, share the fellowship. So you'll soon be getting some information about that. Just wanted to point those 2 things out. And now, without further ado, I'd like to introduce to you our speaker this evening, Mr. Rust Reid, who is going to be talking about estate planning, something we all need. I need it because I need to figure out what I'm going to do with all those Legos I still have. So, without further ado, Mr. Reid. We'll welcome him.
Did you work out today?
I did not work out. I should have.
I didn't see you there.
Now, Molly's going to work the PowerPoints for me because I haven't ever mastered that technology. I'm an old-time lawyer, and I'd like to start out by saying that I have really, truly, after a long warm-up, have retired from the active practice of law. So this is not a commercial for me. You know, and I don't expect anybody here to call me and ask me for advice because I'm retired. But as Margot will tell you, I go to the office every day to get out of the house. Now, this being church, I'm going to start with in Scripture. One of the multitude said to him, to Jesus, "Teacher, tell my brother to divide the inheritance with me." But he said to him, too loud?
Not loud enough.
Not loud enough, okay. I can make myself heard without the microphone if you'd like.
What'd you say?
Tell my brother to divide the inheritance with me. But he, Jesus, said to him, "Man, who made me judge or an arbitrator over you?" And he said to them, "Beware. Keep yourselves from covetousness, for a man's life doesn't consist of the abundance of the things he possesses." And then he told them a parable. And he spoke a parable to them, saying, "The ground of a certain rich man brought forth abundantly." And he was a successful farmer. And he reasoned with himself, saying, "What will I do? Because I don't have room to store my crops." He said, "This is what I'll do. I'll pull down my barns and build bigger ones. And there I will store all my grain and my goods. And I will tell my soul, 'Soul, you have many goods laid up for many years. Take your ease, eat, drink, and be merry.' But God said to him, 'You foolish one, tonight your soul will be required of you. The things which you have prepared, whose will they be? So is he who lays up treasure for himself and not rich toward God.' So one message from this story is, do your estate planning. Because right there, estate planners have God on their side. All right, well, what is estate planning? Estate planning is the process of determining the assets of your the disposition of your present or future assets, both now and upon your death, in accordance with your wishes. And traditionally, those of us who are in the business of estate planning, which I was for many years, to do it at the lowest tax cost. And that's, as I'm going to tell you, that used to be a major effort of professional estate planners. Save taxes. It's much less of a problem today, and I'll expand on that. Estate planning should be an ongoing process, reviewed, updated, and revisited as you age, and your family changes, and your estate changes, and the tax laws change. Changes to estate and income tax laws require review of old plans. And I'll come back to this, but I'll say it now. We, over the last 6 or 7 years, we've gone from an estate tax system that was a major concern for a significant part of the population. We had exemptions going back to somewhere around $2 million. A few years ago, we moved that up to a $5 million exemption, which meant a husband and wife could dispose of, with basic planning, could dispose of $10 million without paying any estate tax. And today, the rates have changed so that most of us in this room don't need to be worried about the estate tax. The first $11.4 million is free of the estate tax. And that's, we'll come back to that again, but today, when we think about estate planning, 90% of what we're doing, or 95%, what many people are doing, is not tax driven anymore. It's a question of what do you want to do with what you have, and we don't need to worry much about the tax collector. Now, and obviously there are people who have $11 million, and I hope that they have excellent estate planners helping. You need a will. I'll come back to that too. If you don't have a will, where does your property go? Who decides? Well, they decide down in the big circus in Austin. The state of Texas says where your estate goes if you die without a will. So you either, if you have property and don't have a will, don't worry. The legislature has said where your property will go. And I'm going to spend some time talking about what those rules are. If you don't have a will, and you have minor children, you can't name a guardian for the children because that's something you want to do in your will. You can't set up a trust because the legislature doesn't have anything in their plan for you to provide for trusts. If you have a will, you will save probate costs. You'll be able to name who will wind up your estate. That will be your executor whom you picked and you named as independent. That is to say, we have what we call in Texas an independent. Boy, you're doing good keeping up with me. I was supposed to nod at
You're
you.
so fast, I'm having to work at it.
Okay, well, we're doing fine. Anyway, you can name an executor. You can create a trust if there's a need for a trust. You can save probate costs. And maybe if you, in some circumstances, you will actually save taxes. If you have a question about this, you may include in your will your appropriate funeral and burial wishes. If not, your family's going to get to fight over that. We hope they won't, but I can tell you they do sometimes. In thinking about estate planning in Texas, the big issue, whether it's in estate planning as we're doing it or as the state of Texas has decreed, you have to know what your property is. Is it community property? If you're married, is it community property or is it separate? And what you think, well, I know what's mine and I know what I had when I got married, but it turns out to be an area that is fraught with potential dispute. In Texas, we are a community property state, which means think of a streetcar named Desire, and Marlon Brando, speaking to his bride, says we have in Louisiana something called the Napoleonic Code. Well, that is a system of community property, and then he goes on to tell her, which is wrong, but he tells her, so half of everything you have, I have. Well, of course, that was really her separate property, but Marlon Brando in that film was not too bright, so anyway. So in Texas, the rule is everything that's not separate property is community property. And there is a presumption, and that's a big deal in the law, a presumption that if you got something and you can't say whether it's separate or community and you're married, it's community. The burden is on anybody who asserts that this particular property is separate property. They've got to prove that because the presumption is everything is community unless you can prove it's separate. So what's separate property? Well, it's separate property which you owned before you got married. That's easy enough. It's property received during marriage by gift, inheritance, devise. Property in this mobile society, people move from state to state. If you acquired your estate while you were a resident of New Jersey, that property would be your separate property because they don't have a community property system in New Jersey. You move down here, you've moved into a community property estate, but that doesn't mean that your separate property is turned into community property. It's still separate property. If you keep records and keep track of that kind of thing, because remember, the presumption is that whatever you have when the estate dissolves by divorce or by death, that the property is presumed to be community. But that doesn't mean it is, because if you acquired it out of state and you keep track of it, then it really is separate property. There's a limited exemption for recoveries for personal injuries. If you are in an automobile accident and you get money from the defendant, that's your separate property, except to the extent the money you received is on account of lost wages, because wages would be community as received. Property exchanged for separate property. You come into the marriage and you own a farm out here in Plano, you sell it, you got the money, and you buy a portfolio of securities. If you keep track of that, those securities will be separate property because that's property exchanged for separate property. Property designated as separate in a marital property agreement, either before or after marriage. You can by contract turn separate property into community and community property into separate. And furthermore, you can in a marital property agreement agree that the earnings from separate property will be separate property. Now, in these days of second and third marriages, and we're living longer and longer, the identification of separate property may be very, very important to your planning. So if it is important, then it's important that you keep records. If you sell Blackacre, the farm, and invest it in securities, you ought to keep track of that, because the securities on hand, regardless of whose name they are in, will be presumed to be community. So if somebody later wants to say, no, that was separate property, they got to prove it, and records are crucial to that. Now, so community property, there is a presumption, and it clearly is community property all property acquired during marriage that's not separate property, including your personal wages. Income from separate property is community property. If you've got a portfolio of securities and you're trying to keep it separate from your husband, the income from those securities will be community property unless you have an agreement, a written agreement to the contrary. So income from separate properties includes interest, rent, dividends, anything else you can think about. Now, I'm jumping over community property, no will. I'm going to tell you a little bit about the laws of intestacy. The laws have changed since I started practicing. So the easiest, the sort of good news is, if it's a traditional family, husband, wife, and children of that marriage, then if one of the spouses dies, the entire community estate goes to the surviving spouse. That's good news. That's good news because that's what most of us, our first thought is, well, of course I'm going to take care of my spouse. And so people can rest comfortable with that. However, and by the way, the law used to be, when I started practicing, that if you died with community property, half of it was your half, the deceased person's half, was inherited by the children, and the widow was left with only her half of the community property. Now, she might have other rights, she'd have homestead rights, but somebody dying without a will was a terrible mess. Even if they had children who were children of the marriage, that the deceased person's half was inherited by the children. And cleaning up one of those situations and living with it can be a nightmare and extremely expensive. And so that was, at that time, even a couple who just had children of that marriage, they really needed a will. So today, the community estate, if the children are children of the marriage, is inherited by the surviving spouse. If there are children, and at least one is not a child of the surviving spouse, just incidentally, adopted children are just like natural children. That doesn't change anything, or that changes everything. Their adopted children are treated just like natural children. But if there are children, and at least one of them is not a child of the marriage of the surviving spouse, then it's back to the old rules, half to the surviving spouse and half to the children. If you're in that situation, you need a will as soon as you can. Rush out to your family lawyer, friendly lawyer, and get a will. If there are no children, all of the community property goes to the surviving spouse. And where it really gets messy is if there are surviving children. Oh, I'm sorry, first of all, it's separate property. If there are children surviving, the separate property goes, the wife or surviving spouse, I keep saying wife, it's the surviving spouse gets all they get is a life estate in 1/3 of the real property. And they get 1/3 of the personal property. That could be everything, and there are more complicated rules to provide for a family allowance and that kind of thing. But basically, the stocks and bonds that were separate property will go 2/3 to the children and 1/3 to the surviving spouse. So it's separate property. The point, I'm not going to go much further than that, but trust me, it's a mess. We had a young lawyer in our office who recently died, and unexpectedly, and this is not unheard of. That lawyer did not have a will, and they had 2 children, and you would have thought they hadn't been married long, that everything they had was community property. But no, he had inherited a 1/8 interest in some mineral properties that were his separate property. And when the court found out about that, the court said, I'm not going to let you have an independent administration. We're going to have a court-supervised administration. Because this was a lawyer in our office, we didn't charge anything, but we kept track of our time. And if we had charged for that, we would have charged tens of thousands of dollars to that widow. The court made us jump through every conceivable hoop to protect that small separate interest. It was just a nightmare. So all of this is to say, you need a will, doggone it, you need a will. On page 10, let's see how we're doing. Separate property with no will. That
There we go. You good?
you're in the right place.
Okay, great.
Great, excellent.
Okay.
If there are no children, the real half goes to the surviving spouse and half goes to the parents, But if a parent is dead, then it goes half to the surviving parent and the other half to the brothers and sisters, the descendants of the parents, and then and on down. And if you find you can't get, the parents don't have any descendants and they're deceased, then you go back up to the grandparents and find their descendants. It's to be avoided. I don't have a slide on this. I said you need a will. Well, there are 2 kinds of wills in Texas. I think, well, there are 2 kinds of wills. There's what's called a holographic will. If you think you're smarter than anybody, you can write your own will. And as long as it is entirely in your handwriting, it doesn't have to be witnessed. There are no formalities. It just has to be all in your handwriting and signed by you. And that is technically a valid will in Texas. And if all you want to do is leave everything to your wife and not, you're not worried about your children or anything like that, then you can, literally, there are wills that have been probated, say something like, "This is my will, all to Susie. Sign it." That's a perfectly valid will in Texas. It has to be all in your handwriting. We had another situation. How are we doing on time? We got plenty of time.
You good?
I somehow got involved, it's a long story, but in representing one of the people who had been wrongfully convicted and spent significant time, over 20 years in the penitentiary. And he was wrongly convicted and he was finally exonerated. And shortly after he got married, or after he got out of prison, he married this wonderful woman. And then he got a very large recovery from the state of Texas, hundreds of thousands of dollars. And he went out and bought a house with the proceeds that he got from the state of Texas. And he said, "That's my wedding present to his wife." The trouble is that he just put it in his own name. He was dying, and he got his niece to come in, and she said, "You need a will." And he said he couldn't write. So he dictated the will to his niece, and she wrote it out, and he signed it. And then they were very worried because they weren't sure it was right, so they had a notary public come in. And the notary notarized the will. There were no witnesses. It was an invalid will. And again, incredible effort in trying to track down the heirs, his heirs, because it was probably his separate property. And, well, just, you need a will. And the point of that is that was a will that almost qualified as a holographic will, but it didn't. And otherwise, you have to have two witnesses. It has to be attested. Now, so then, well, what is governed by your will? Well, what is governed by your will is all of the property that is in your probate estate. That isn't necessarily everything you own. You own a life insurance policy. There's a beneficiary. That money goes to the beneficiary. It's not part of your probate estate and is not governed by your will. Your employee benefits. Many of us have, and more of us will have, 401ks, IRAs, and those assets are governed by the beneficiary designation. So those are called non-probate assets. And they pass in accordance with the beneficiary designation, not in accordance with your will, unless you leave it to your estate or haven't named a beneficiary, and then it does go to your estate. Joint tenancy with right of survivorship can be created in Texas, but you have to be careful. In common law, in a common law state, if you say joint tenants, that means joint tenants with right of survivorship, but not here. You've got to have the language that says, it has those magic words, with right of survivorship. Don't think a joint account satisfies that unless you happen to, the bank's form, which most don't even read, the bank's form may say joint tenants, but doesn't say with right of survivorship, and therefore it doesn't go to the surviving spouse. It's governed by the will. And those can create bitter feelings. Suppose you're very close to your daughter, but you have two daughters. You're close to both of them, but for convenience, one of them, you open an account, and the form says joint tenants with right of survivorship, and all of a sudden, that daughter gets the bank account when the will left everything 50-50 to them. So the daughter who's on the account gets it. I've had this situation, and the daughter said, that's the way it is. She took it and did not share it with her sister. She wasn't obligated to. She said, well, mother wanted me to have it. So, if that's what you want, joint tenancy, right of survivorship, then you have to use those magic words. Not just joint tenants in common, or one thing many of us do as a convenience, I'll open an account in my name. It's not in my daughter's name, it's in my name. But she's an authorized signatory on that account. In theory, when I die, that account is supposed to be frozen. Now, the banks don't always pay a lot of attention to it, and sometimes the money gets gone before the will gets probated. But in theory, if the account is in my name and my daughter is just a signatory on that account, as soon as I die, her rights to withdraw from the account terminate. And the other form of non-probate property is trust property. Suppose I create a trust while I am living, both for my own support, and then it provides that upon my death it will continue to be held in trust for the benefit of my wife and then to my children. That's called a testamentary trust. Or no, that's a living trust because it's created for my own benefit. It's a living trust, it's not a testamentary trust. The terms of the trust govern, and what my will says doesn't make any difference. So if you're going to have a trust like that, you need to pay attention. Another thing that, of course, you can do in your will is create a guardian for your children. This is, for young couples, this is a recurring concern. One reason a lot of them will write their first will is the one thing they're worried about is who's going to take care of the children if we both die. And who the guardian is, needless to say, is very important. Okay, a word about trust. I'm now on page, I can't see. It's page 14.
Okay. What you got?
Now, this is a simple. Go back to the one with the pictures on.
Go back to 13.
There we go. The settlors, the person who established the trust. It's interesting. In this slide, we decided to show a bank that's in the middle, but it doesn't have to be a bank. You don't have to have a bank trustee, but a trust is sort of a big deal in the estate planner's bag of tricks. And basically, it is a three-party transaction. The settlor, the person who establishes the trust. The trustee may be an individual or a bank, and a beneficiary. Further, any two of the roles can be handled by the same person. So I can create a trust naming myself as trustee. That's a living trust. And the beneficiary then gets their benefits when they get the benefits. By the same token, the beneficiary can be the trustee. And vice versa. You can create a trust for your own benefit using a third party as trustee. And a lot of people have done that. I'm sure there are people in this room who are the beneficiary of trusts, and they're also a trustee. It's kind of common. I die, I leave my estate to my wife to hold in trust for herself for life, and then to go to my children. She has two hats. She's the trustee, but she doesn't own the trust. She is the beneficiary of the trust, and when she dies, what's in that trust will go as I directed in my will or in my trust agreement. So again, two of the three parties can be the same person. Now, whether we ought to do that is something we're going to come to in a minute. But let me say another word about it. The most overlooked thing in trust planning, and it comes up over and over again, if you ask the lawyers in my firm, what's the biggest problem we have with trusts? The biggest problem we have with trusts is either there's no adequate provision for a successor trustee, or it's the wrong person. You create a trust and you say, well, I'll let one of my children manage it for their mother, and the trustee's brother is not named in that capacity. And I'm reminded of what my children used to say when they were little, and they would get into a squabble, and they'd say, well, who died and made you queen? And I heard that a lot. If you name one of your children as trustee, there's an excellent chance the other child is going to be very unhappy. I'm not saying don't do it, but think about it. Think about it. Just don't just assume, well, first trustee is going to be the oldest, and then the next, and the next, and the next. And then it was a habit of a lot of people here in Dallas, particularly when the banks were Dallas institutions, they'd name widow, son, and then say, if they're all deceased, First National Bank. And then it turns out that's a very big estate, and the sons get into a squabble and they say, but they don't want First National Bank of all things. A lot of people don't like banks. And so then when we have to go to court and determine who's going to be trustee, that's the biggest problem of the succession trustees. So in your planning, if you're going to name a trust, create a trust, either provide for a long-term list of people who you think will work, or have a mechanism in the trust for the family to select a trustee. And they may fight about that, but it's much easier than fighting about that in court. There are two kinds of trusts: inter vivos, between living people, created while the settlor is living, and it may be for the settlor's benefit. We refer to that kind of trust as a living trust. I turn my property over to a trustee, and the trustee manages those assets for me now, and then when I die, the trust continues for my beneficiaries. And this is very wise in some cases. Who's going to take care of you when you're old and frail? So you may decide, I'm going to put all my property in trust. I'm going to name one of my children or my best friend or a bank to manage the assets for me while I am living trust. I'm getting the income. It's going to be included in my taxable estate, but when it dies, the assets will go as I direct it. They may stay in trust for my wife. It may stay in trust for my children's lifetimes, because I'm really worried. I have 4 daughters, and I'm worried that they happen to happily married, but I don't quite trust their husbands because they're the husbands of my wonderful daughters. Nothing against the husbands, but I would rather not have them have their inheritance from me. I'd rather put it in trust, give them the benefit of it, and then have it go guaranteed to my children, so their husbands won't either squander it on riotous living or lead them into bad investments or all the things that can happen. I want to protect it. I want to protect my wife. I want to protect my children, and I love my grandchildren. I want to be sure that it will ultimately go to my grandchildren. Those are non-probate assets. They're not subject to the probate court, and that's why a lot of trusts are created. A testamentary trust, on the other hand, is a trust created pursuant to a will. I leave all of my tangible personal property to my wife, or she's not living, to my children. I leave the homestead to my wife to live in, or leave it outright to her. But I leave the rest of my vast estate to a trust to protect my wife, and maybe I may name her trustee, and and still those assets will then pass to my children, even if my wife gets crosswise with one of my children. I've said I want them all treated equally, and so my half will go as I have directed, and you run less risk of your wishes being thwarted. I've talked about a living trust. You can create it now. You can fund it or not fund it. Sometimes we'll create what we call an empty vessel. We'll create the trust agreement is signed, the trustee signs out, but I don't put anything into my trust right now, but it's available if I want to transfer my assets, or if I start to slip, and the person who holds my power of attorney decides, well, I'll go ahead and fund the trust because he's already written the trust. The trust, it's a standby trust, or what we would call an empty vessel, and then I can fill it when I want, or my will says upon my death, everything I have goes into that empty vessel. So I've got the trust, which is separate, and the terms of the trust at that point are not a public record. The will is a public record. So if you're one of those people who is worried about privacy, one of the real advantages of a living trust is that it's private. A will must be probated. You don't have to have any proceeding to validate a trust. It's valid when you sign it. You don't have to have a will. If you could put everything that you owned into the trust, then there's no need to probate the will, because the only asset is the trust, which is a non-probate asset. Some people are very afraid of probate. They talk about avoiding probate. That is largely a bugaboo in Texas. We have a wonderful thing that we've had in Texas for time immemorial called independent administration. And that is, you can name your executor, and if you say independent without bond, that means that the executor winds up your affairs without the supervision of the probate court. The executor doesn't have to report to the court. They go ahead and administer the will in accordance with these terms. The only thing you have to do in the court is to have a 5-minute hearing before the judge. You file the application to probate, you wait a few weeks, you have a very short hearing, the will is admitted to probate, and the executor then has the power to wind up your affairs. She doesn't have to post a bond, because you say independent executor without bond. So there's no bond, there's no court supervision, and the result is Texas probate has become the model for many, many states that people are coming to realize they don't have to get tied up in the kind of procedure that you have, say, in New York, where a will, once admitted, remains under the supervision of the court for years, and the costs are astronomical compared to what we're able to do in Texas with independent administration. A good reason to have a trust, a living trust, is out-of-state property. Suppose you own a vacation home in Colorado, and you die, and your will is admitted to probate here in Texas. Does that work in Colorado? Not necessarily. The will is valid, but in many states, the will has to be probated in the state where the real estate is located. So you have to have two probate proceedings. And you try to convince somebody in Iowa that this was community property, even though it was all in the husband's name, they act as though they never heard of community property. And so you've got to go up there and convince them. It can turn out to be very, very expensive. You solve that problem by putting the property into a living trust now. That's the conveyance. The trustee holds title, and when you die, the trustee continues to administer that trust, even if all they're doing is distributing it outright to your beneficiaries. But you avoid that ancillary probate in another state. Many people I mentioned are concerned that a will is a public document. You can go down to the courthouse and look at a will, and you know what that person did with their estate. Now, some people, I don't think there are many people going down to the courthouse and seeking dead people's will. That's very, 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 very rare. But if you're a celebrity, sometimes you will read in the paper the terms of somebody's will. Well, how do we know that? Well, because a smart reporter thinks there may be something interesting. They're going to go down and get the will and read it. And if there is an inventory file, that inventory is also a public document. So they not only know what your property, where your property goes, but also how much it is. Now, there are ways today to avoid the filing of an inventory, but it depends on the particular situation. So privacy is of great concern to some people in favor of a trust. As I said, the assets in the trust, remember, are non-probate assets. And therefore, if you have if you could get all of your assets into the trust, then there's no need to probate the will. Almost always, when we create a living trust as a document to pass your estate upon your death, we also have a will which is called a pour-over will. And a pour-over will merely says, whatever, I leave my tables and chairs and cars and that kind of thing to my wife or my spouse. I may also leave our home either outright or a life estate in some form. And then the residue of my estate pours over into this trust. In some cases, obviously, trusts have been a huge tool relating to the estate tax. And how are we doing on time? Well, we're supposed to stop on
You have 7 minutes.
7 minutes. Gee whiz, I've got.
25 seconds.
Okay. All right, I'm gonna. What does your executor do? Your executor, if you die and there's a will or there's an executor or an administrator appointed, they pay your bills, they file any necessary tax returns, and that includes your final income tax return. If I were to drop dead tomorrow, somebody would have to file my 2018 income tax return. That's a job for the executor. Now, if you're married, that is still Margot's problem. Filing a necessary tax return, you have to marshal the estate, determine what the assets are there. If they're named beneficiaries, transfer them, net of debts, to the beneficiaries named in the will or trust agreement. Now I'm going to talk for about 2 minutes about the estate tax, not much, because we have had this radical change in the estate tax. Going back 10 years ago, we had a $2 million exemption from the estate tax. That meant that many, many people who weren't very rich by today's standards, but who suppose somebody owned a house in University Park, and all of a sudden, those bare lots are worth over $1 million. So many people, the upper middle class, were subject to the estate tax. Without going through the succession, as of today, the estate tax exemption is $11,400,000 per person. That means that a husband and wife can dispose of $22,800,000 tax-free. And traditionally, the way they would do that is they would put, the first spouse to die would put his or her estate into a trust for the surviving spouse. Those assets would not be included in the surviving spouse's taxable estate. So that two people working together could have used two exemptions. And in today's means, that means that with reasonable estate planning, a couple can pass over $22 million without paying any estate tax. Now, suppose you're a couple and you have a will that was written 15 years ago. It's in your safe deposit box. You haven't looked at it lately. The will was created to avoid estate tax, because you were worried that if you had $5 million and there was a $2 million exemption, you'd pay estate tax on $1 million. If there's a 40% tax, that's $400,000. So you could, at that point, you could hire a lawyer, pay him $1,000 to $3,000 to write a simple will creating a trust, a bypass trust, and save your family, in that case, $400,000, $500,000. It's so most people who have had any level of sophisticated planning have provided trusts for the surviving spouse, which will save significant estate tax. But if that same couple today, all they have is, they're very comfortable. They have $9 million. That old will with that trust designed to save taxes, you don't have to have that will. You could leave the $9,000 to your spouse. She could do whatever she wanted to with it, or he could do whatever he wanted to do with it. And when he or she died, if it hadn't increased in value, there'd be no estate tax ever paid. The government wouldn't take a penny if you're up to the exemption level. So if you have a will that was written 10 years ago, or even 5 years ago, get it out and review it and see if you want it to be the way it was. If the trust was created primarily for tax reasons. There are people all over the country who have got wills with trusts in them, and they wouldn't have written the trust in the first place except for tax savings. And so today, they'd be perfectly happy to have everything go to their spouse outright. They're not worried about estate tax. And it's a long, healthy marriage. Yes, indeed.
Russ, what happens if the administration changes?
Well, good. That's a very good question. Well, it doesn't have to be just the administration. It also has to be the Congress. But there is a risk. There is a risk. I mean, we have radically changed our attitude towards the taxation, at least today, towards the taxation of wealth. And we provided that 98, 99% of the population today doesn't worry about the estate tax. But there are many people out there who believe that the estate tax provides a useful function. Not only does it provide a little bit of money to the government, but it is a social engineering tool to break up vast estates. Whether you agree with that or not, I think it is conceivable that with a change of administration, those exemptions would be reduced. But it's I don't know. I just say that. So if that's what you're worried about, then create a trust in your will, and at least use whatever exemption is available, so that if they drop the exemption down to $2 million, then you're still protected to get the benefit of not having that $2 million taxed in the survivor's estate. Excuse me. So that is a legitimate concern. I think we, by and large, for planning, however, we need to deal with the problem that we have, the situation that we have now. Gift tax is a crucial giving for people who are worried about taxes. Giving is a key element of giving. You can give to as many people as you want. $15,000 each every year. Every year. And that means a couple can give $30,000 to as many people as they want, each and every year. You don't even have to file a gift tax return. You just give it to them, keep it in your record, and if you do that if you got, suppose you got 10 grandchildren, that's not unheard of. If you got 10 grandchildren, you can give away, husband and wife can give away $300,000 a year and never tell Uncle Sam. Furthermore, some of us have this situation. Anything you give to your wife, first of all, is outside of the system entirely. But you can also, if you've got children in college, you can pay their tuition. That doesn't count against the $15,000. You can pay direct medical expenses. You can't buy them health insurance without it being a taxable gift. But you can pay directly to the school their tuition and never file a tax return reporting that. Just keep track of it. Yeah.
You do that for grandchildren as well, or just for
Oh
children?
yeah. Anybody. You can create an education trust for my children if you like, or my grandchildren.
I've still got 2 cents in college, so
And
take donations for them.
I'm sorry.
I've got 2 cents in college, I'll take donations.
Sure. Okay. If you're in the estate tax business, it's everything you own, basically. And those things that were non-probate assets, life insurance, beneficiary designation, they are included in your taxable estate. I'm going to skip over that because, frankly, if you've got $22 million, you don't need to be here listening to me. I hope you have a highly qualified estate planning lawyer who's helping you. I've talked about the bypass trust. Now I'm going to come to the last idea that they slipped in with recent tax litigation. Used to be in order for a surviving spouse, well, let me put it the other way. If a testator left everything to his spouse, that would pass to his spouse tax-free. But if she owned it outright, then when she died, everything over her exemption would be subject to the estate tax. Follow that so far? So that's one reason why you would put property into a so-called bypass trust. Well, Congress looked at this recently and said, well, that's crazy. Why don't we just say that if I leave my estate to my wife, then when she dies, she can not only use her own estate tax exemption, but she can also use mine, even though I'm dead. And that concept is referred to as portability. My exemption is usable by my widow, and so she can get the advantage of two exemptions. However, having given away, they also take back. One, you have to file a tax return with the government and elect portability in the first estate, even if that estate isn't paying any taxes. So you have to go to the trouble of electing portability. And then there's another hooker in there. The surviving spouse marries again, and the surviving spouse, so when she dies, her second spouse is her last, and her second spouse dies before she does. The first spouse's portable exemption vanished when she married and he died. That's just out there. So there is a potential tax trap in there. And if you're in that situation where your combined exemptions would exclude, under present rules, $11,400,000, then you ought to be aware of that risk to portability. So I'm skipping over. And on page 26, you did it. You just watched me flip the page.
Just watching the pages, yeah.
You can, not only can you leave property in trust for your wife, but of course you can leave property in trust for your children. And if you do it right, and if the numbers fit, you can, by doing that, what you leave to them will not be taxed in their taxable estate when they die. That's called generation skipping. And it enabled vast wealth in years past to pass down from generation to generation. So a family like the Kennedys, say, 3 or 4 generations, they paid estate tax once, and then it passed down in these trusts. So eventually, they created something called a generation skipping transfer tax, which basically subjects the property passing upon the death of a child to his children to tax if it exceeds the generation skipping transfer tax exemption, which is the same as the estate tax exemption. So again, we're not worried about that as much as we used to. All right, the last thing I'm going to mention are the the other estate planning documents. Suppose the testator has a stroke, and everything is in, we're on page 27, yeah, you got it right. Everything, for whatever reason, is in my name. If the surviving spouse or other family member has a power of attorney, a general power of attorney, then they can continue to manage your affairs even though you are incompetent. The banks have gotten very sticky, and security companies very sticky about using, honoring powers of attorney, but the legislature has tried to make it mandatory. Having a general power of attorney is far better than not having one. Whether it'll work every time, I can't guarantee, but everybody in this room should have somebody who has their power of attorney, who can act if they are incapacitated. I think I'd say that without exception. And it may be you give it to your spouse, so it's clear that your spouse can act on your behalf. But then have a backup, a child or other trusted person. Medical power of attorney. Last week there was mention of the problem with the medical power of attorney. Medical power of attorney authorizes the holder of the power to make medical decisions for you. And remember last week's speaker said that won't work. It will work if you are incompetent. As long as you're competent, your children can't come in and say, pull the plug, or she has to have her leg amputated, or something like that. As long as you got your mind is working, they can't use the power of attorney to override your wishes if you are competent. So the medical power of attorney only comes into effect if you are incapacitated, incompetent. And so, but if you're hit by a car and you're comatose, the holder of your power of attorney can make medical decisions for you. Who else is going to make them? So it is very wise to have a medical power of attorney, but we do understand that doesn't mean the holder of the power of attorney can override your wishes as long as you're competent. So a directive to physicians, many of us live in fear of being kept alive indefinitely on a machine. And I urge you to think about that. If you want to have what's called a directive to physician and family or surrogates, that's the legal title, but generally referred to as a living will. Think about it. The holder of your medical power usually will have the power to act on your behalf in connection with the directive to physicians. It's a way for you to make your wishes known. If you don't want to be kept alive indefinitely, you can craft that power of attorney however you want, that directive to physician, however you want. And we rarely, I don't believe I've ever seen one used in 50 plus years of practice, where somebody has actually said, pull the plug, or don't pull the plug, whatever. So, but it's out there just the same, and people worry about it. So think about it, get it right. If you're worried that one of your children is estranged, and if you become incompetent, they're going to come in and try to take over your affairs and go to the court and get named as your guardian, you can right now say, I designate so-and-so to be my guardian if I become incapacitated. Most people don't do that. They're not worried about it. They figure their children will get along or whoever it is. But if it's something you worry about, then think about the Declaration of Guardian. And the last thing is what's referred to as a HIPAA declaration. Technically, if you go in the hospital, the doctors are very limited in how much they can talk to your spouse, how much they can disclose about your medical condition. Now, obviously, wise doctors consult with the family. It really does happen in almost all cases. But if somebody raises the question, and if you have a HIPAA declaration, then they are obligated to share your medical information with the person who holds the declaration. So think about that in your estate planning. Income tax savings are beyond the scope of this presentation. However, our church, just for your information, is in the process of developing material for encouraging sophisticated giving, including use of IRA minimum required distributions directly to charity, say, for example, to the church. The most tax efficient way to take money out of your IRA, those of you who have passed that magic year of 70 and a half, and there's an IRA, you have to take a designated amount out of the IRA every year, and that's taxable income to you, and you have to take it. But you can give it directly from the IRA to your charity. And therefore, the income, which would up to $100,000 a year, the income which would otherwise be taxable to you isn't included in your income at all. So you're not limited by any restrictions on the size of your charitable giving. And we have, in the current tax law, we've raised the annual personal exemption. So in many cases, you're not going to get any use from your charitable contributions, but if you take them out of your IRA, they can go directly to charity, past the tax collector entirely. I just mentioned, and Andy's here. Andy is.
We're going to talk about this next week a little bit.
Yeah, we're gonna continue the conversation next week.
Okay, that's going to be.
You'll be here next week.
Okay. Well, just be aware that we have designated a plan giving process or giving process consultant in the church. It'll be put out shortly, and it's another tool. We also have the church's foundation, and those are other tools available. Okay, so my conclusions. I'm just about
Yeah,
in.
if you wanna take a couple of questions.
I will,
maybe a couple of
but
questions.
let me give my conclusions
Sure,
first.
go ahead.
If you don't have a will, get one done. By the way, don't try to do it yourself. I've seen people, you turn on the radio, it's on National Public Radio. You got somebody who's advertising, we'll write wills for you. It's just outrageous, because if you try to do it, I guarantee you'll mess it up. You'll do something wrong. And so to save a few hundred or a few $1,000s to using a will that is drafted by somebody you never saw, it's just nuts. Don't do it, no matter how tight you are. If you have documents that were executed more than 3 years ago, look at them. You don't have to change them, but look at them. Be sure you got it right. Review your fiduciary appointments. Who's going to be your executor? Is that still appropriate? Who's going to be, if you have young children, trustee for your children? In many cases, old plans are obsolete today. You may have a far more complicated estate plan than you need, given the current tax structure. And finally, I urge you I think there's a lot of gray hair here. Talk about your plans with your children, or consider talking about it. Now, a lot of people can't bring themselves to sit down and talk to their children about what they're doing. But if you bring them in, you may find that it really helps. You get their insight. You may find that you say, well, I'll leave it outright to you, or put it in trust for you to your children. And that child is not necessarily going to say, I want it outright. That child may well say, I'd like a trust. Protect me to have a trust that is protected. That that my creditors can't reach, that my greedy husband can't reach. So bring your family in, talk to them. It's hard to do. It's hard for me to do. It's tough. But think about it, and for goodness sake, if you don't have a will, write one. Thank you. That worked great. I didn't even know you could do that.
Does
So
anyone have any
I'm available to answer questions. I'm deaf, so if you have a question, make it loud.
Here's one right up here.
If you have an account and you have a POD on it, how does that affect the estate?
A POD account,
Yeah.
you need to look at it and be sure it legally works. But you can have, I believe you can have such account. I don't know, but you want to be sure that it really does work. And I don't want to go beyond that because I'm not familiar with that question.
Oh, here's one.
Don't give us some idea of how they hear the cost of probate.
How the what?
The cost of probate.
Cost of probate.
Goodness no. A simple will, getting it probate, and even filing the necessary tax returns, if there are any, administering the estate, can run anywhere from a few $1,000s to literally hundreds of thousands of dollars. How big is the estate? How complicated is the estate? The actual cost of probating the will and getting the executory name is nominal. I mean, less than $2,000. And then the executor is in place, and the independent executor operates without court supervision and control. Now, why do you need a lawyer at that point? Well, one thing that's happened is our probate practice isn't as lucrative as it used to be.
Say half of your total assets were stock, bonds, whatever, cash, and the other half of your total assets were designated to give to charity. Do you deduct all that charity from what they charge for the probate?
It is part of the probate estate, but the value of the estate doesn't make any difference how complicated the administration of the estate is. Lawyers are not paid. Years ago, we had a good deal. You used to be able to get a percentage of the estate. They still do in many other states, but not here. Your executor, your lawyer, is going to be paid for the time he spends. And that's, you don't know how much room that's going to be. Now, if there is a professional executor, if you name a bank as your executor, they're going to charge a percentage of the estate. And that could be anywhere from 1 to 5% of the assets under management. So a professional fiduciary, a bank, will charge a lot of money.
Any other questions? Okay, well, thank you all very much.
Still this, because I don't scream as loud. Thank you, Russ. This is a complex subject, as you know, and so we thought we would probably need a follow-up next week. So next week, Andy Robb is going to be here as our speaker. We're also going to cover, we're going to talk about tax law some more, and probably if you have other questions you think about this week and you want to come back, and we'll hopefully delve into those as well. Please come in here, Andy. Kind of a continuation of the changes to the tax law and what you can do to help plan well. Also, we're going to also talk about end-of-life decisions. You know, Russ touched a little bit on planning end-of-life decisions here at the church, with pastors, with your funeral or your arrangements to make it easy on your family. We're going to touch on those things too, to make it easy. I can tell you, as a pastor who's been a pastor for a lot of years and done a lot of funerals, there are situations that have been kind of dicey with families on occasion. not that you ever want that to happen, but you can really bless your family by making your own decisions about how you want things to go once you are gone, so that they don't have to make those decisions. We're going to talk about those and what your options are, so you can at least think about those. So please come back next week and join us for our last Be Prepared. We hope you are getting something out of this. That is our plan for you to feel like this is worthwhile time you're spending. So thank you very much. Have a great week, and we'll see you next week. Bye-bye.